case. What do you make of the decisions that have been rendered this evening?
The court has expressed itself that many of the applicants who wanted to join the case as either amicus or interested parties have not made the threshold required by law, and also they have not exemplified themselves any more than any other Kenyan who would have as well had an interest in the case. And so many of them have been removed. But I think they have specified the Law Society and the Attorney General and restricted them to specific issues so that they can make addresses on those issues and help the court appreciate the legal issues involved. Yeah. But as you know, they have reserved our issue of scrutiny.
Yes, what do you make of that?
Well, I can only wish for the best, and I pray. Because at this moment it is purely within their province to make a decision. I don't think there is anything more than the fact that they had many applications to deal with. Yes. But as they say, 9 o'clock we will know how it goes.
And the National Super Alliance, the petitioners here, you have 28 issues, and the judges have said in terms of the issues, they will not frame them, they will leave the parties to be able to argue out their cases. So do you have specific lawyers for the specific issues? Have you divided yourselves out to be able to tackle specific issues as a team of lawyers? Because you're quite a number.
Well, you know, we have a tyranny of brains there. Yeah. More than 47 or so prominent lawyers with many years standing. Yeah. But we are working on a strategy, and it is never done until it is served. So you might as well wait and see how we do it tomorrow. But yes, there are issues that we will look at. There may be more. You know, in this petition, everything is in issue.
Yeah.
Well, you kind of everything, well, everything is in issue. Yeah. And so I think we will express ourselves very well. Many of the issues which can be condensed will be condensed. But I think everything, as I told you, is an issue.
All right. Many thanks. There we have Tom Kajwang, legislator. Excuse me, ma'am. We are live. Forgive that. We want to be able to cross over to the other side to listen to what also other council are saying. Harrison Kinyanjui, you have been successful tonight, haven't you?
Yes, I have.
How are you feeling? Talk to us about that.
No, it's pretty good because you get a podium, a platform to articulate issues that cut across the election. I mean, if you are a presidential candidate, you saw what you saw, and you wonder what is being said. Is this a mysterious thing? Or so the platform is welcome, and I believe we will articulate the issues that are necessary.
However, you are denied amicus curiae. You are only allowed as an interested party.
No, it doesn't really make a difference. What we were saying, if the court enjoins us as amicus, all the good. If they enjoin us as respondents or interested parties, that's pretty good.
All right. Many thanks. Thank you so much, Harrison Kinyanjui. There's also Charles Kanjama, who I see trying to not... Charles Kanjama, good to see you. So you are disallowed your application to be amicus curiae. Talk to us about that.
You know what happens when you make an application for amicus? You want to be a friend of the court. And when you make an offer to be a friend of the court can accept your offer of friendship or can say they don't need you to be a friend. So when you apply to be amicus, you're meant to be objective and neutral. So you don't have any stakes in the outcome. If the court says they don't want you to be amicus, you move on to other things. So that is the end of my participation in the matter, but it was good while it lasted.
But it was not just the court that dismissed it. All parties rejected and were opposed to your application.
Unfortunately, I didn't see the responses that were filed by the respondents. So, yeah. I just saw the response of the petitioner. And the petitioner opposed the responses of actually everyone, including of the AG and so on. So I think there was just a general sense among the main parties to the case, which I expected, of trying to keep out other parties. It's like this is our playing ground. Other parties keep away. While my view was that this is a case of great public interest, and you need to try and lower down the ultra-partisanship you find in court. By having someone who's objective and an expert who can deal with this kind of issues.
But why did you choose to go it alone, not with the LSK? Because you are chair of the Nairobi LSK.
I don't want to comment about Law Society of Kenya. I'm a member of that organization. They have been allowed, and I'm happy that they have been allowed, because I think LSK has a very important role to play. My feeling, though, is that it would be very unfortunate if jurisprudence develops at the moment the Law Society is enjoined, no other advocate among the 15,000 has any capacity to be enjoined, regardless of any special competence. It would be very unfortunate. For example, Yash Palgai is a lawyer in Kenya and he's been enjoined as an interested party in cases where LSK has been enjoined. I also have previously been enjoined where LSK has been enjoined. So the fact is that professionals who feel that they have special competence and have something to offer to the court should be given an opportunity, so long as the court is convinced that their assistance will be of help. If the court does not think that the assistance will be of help, the court is perfectly entitled, has full discretion to disallow the applications, because the court needs to deal with what we are calling the tyranny of time.
Kanjama, when you talk about competence, what do you think the court is going to miss from your non-inclusion in this petition?
I had indicated in my application that apart from giving assistance on a legal aspect, because I have dealt with electoral cases in all the stages, from the IBC Dispute Resolution Committee, the Political Parties Dispute Tribunal, High Court, Court of Appeal, even in the Supreme Court. In fact, some of the cases cited by the parties are cases where I was a part. I played an important part, successfully argued cases before the Supreme Court. So I think there will be something missing there. I've also been a very close observer of the electoral process. But I had also added that I'm concerned that the case as it develops in the Supreme Court becomes extremely legalized. It's as if all the other competencies that are important in the electoral ecosystem are excluded. For example, there is a role for the accounting profession, because there are various principles and practices that have been adopted by auditors and accountants when they are verifying figures, verifying documents that would have helped the court. And I'm a member of the Institute of Certified Public Accountants, would have provided that assistance. There is a place for information technology. You saw the application yesterday, which is yet to be ruled on, was turning on information technology. And yet there was no person with information technology competence to address the court directly. They could only have provided information through affidavit. So definitely I believed that I would have added to the case. But of course we must respect the decisions of the court. The judges are under a lot of pressure. They have very little time to listen to the case, and then eventually they have to deliver judgment. And I think you can tell from the comments that were made yesterday in court by the Deputy Chief Justice that the judges are inclined to give a reasoned decision on Friday, so that they really need to get the hearing out of the way, of course, after giving everyone who has a right to be heard an opportunity to be heard, then so that they can write a considered ruling or judgment that will satisfy the people of Kenya.
All right. Many thanks. Charles Kanjama there saying the court will be missing out on his expertise in as far as the hearing at the Supreme Court. That officially kicks off tomorrow. It is D-Day. Of course, before that, we will be seeing that extra one ruling that is yet to be made, a crucial one on the petitioner requesting that they be able, applying to the Supreme Court, that they be allowed to scrutinize the servers, to audit the servers and the logs used by the IBC. They made that case very passionately last evening during the pre-trial conference, and it was the only application that tonight the 8 judges of the Supreme Court said will have to wait until tomorrow morning, 9 a.m., when they deliver judgment or ruling on that before going into hearing. So we'll continue, of course, our coverage here at the Supreme Court of Kenya. Being able to speak to quite a number of counsel and interest interesting also to hear this evening Ahmed Nasir Abdullahi appearing for the president, saying the time constraints, they don't necessarily feel them. They think the 14-day period is quite in order. However, you saw James Orengo saying that there needs to be a relook in as far as the timelines are concerned going forward. Let's get a quick word from a man who has been here throughout this evening following the proceedings. Well,